All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to
High-stakes custody battle. A father's struggle unfolds. The courtroom is tense as the judge's gavel echoes through the room, demanding order. At the center of it all is Mr. Thornton, standing firm as he presents his case. He has custody of his teenage son, AJ, and has been making regular support payments to Ms. Hernandez. But behind the legal paperwork lies a deeper crisis. AJ is facing serious criminal charges, including burglary and a reckless police chase that ended in a crash. As the judge digs into the details, the focus shifts to AJ's living situation and whether his financial needs have changed. Mr. Thornton, visibly worn down, lays out the crushing weight of the expenses, legal fees, damages, and the fallout from his son's actions. But this case isn't just about numbers. It's about accountability, consequences, and the harsh reality of raising a struggling teen. The courtroom is on edge as the judge prepares to rule. A decision that could alter the course of this family's future. What will the verdict be? Stay tuned.
stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
if I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support.
A desperate fight for relief. Is it enough? Mr. Thornton lays everything on the line. Miss Hernandez has moved out of state, left her job, and no longer provides insurance for AJ. That leaves him alone to shoulder the crushing costs, medical bills, court fines, and the staggering expenses from the crash. The financial strain is overwhelming, and the pressure is written all over his face. The judge listens intently, but quickly points to a key issue. The previous mediation agreement required no child support. So, the critical question remains: has there been a substantial, undeniable change in circumstances? Thornton argues his case, but there's a hurdle he can't ignore. Since AJ has always been in his care, proving a significant change is an uphill battle. His frustration is evident as reality sinks in. This legal fight won't be easy. The stakes are sky high, but the judge remains firm, bound by the law. Can Thornton find a way to turn the case in his favor? Or is the decision already out of his hands? The tension in the courtroom is rising, and the outcome is anything but certain.
Payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Okay.
In that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed.
The courtroom falls silent as the judge delivers a decisive verdict, leaving no room for ambiguity. For child support to be adjusted, there must be a significant, undeniable change, whether it's a shift in living situations, income, or a child's educational needs. Yet, after carefully examining the evidence, the judge finds nothing has substantially changed since the original agreement was signed during mediation. Mr. Thornton's frustration is palpable. He feels abandoned, believing Ms. Hernandez has stepped back, leaving him to shoulder the burden alone. But the judge remains steadfast. She emphasizes that the agreement was a mutual decision and that the law doesn't yield to emotional appeals. It demands clear, legal grounds for any changes. This moment becomes a dramatic collision of logic and raw emotion. Mr. Thornton's plea for what he sees as fairness crashes against the unshakable wall of the law, creating a tense, gripping scene. And with a final ruling, the gavel falls. Disappointment hangs heavy in the air, sealing the outcome and leaving no space for further debate. The decision stands, firm and unchangeable.
Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean...
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you. Then we can...
The judge's voice cuts through the courtroom, calm yet unwavering, as she delivers her final verdict. Under the law, Mr. Thornton's request for a child support adjustment is denied. The original mediation agreement stays in place, and without a substantial change in circumstances like income, living arrangements, or a child's needs, there's no legal basis to alter it. With a decisive tone, she declares, "Case dismissed." Mr. Thornton responds with a quiet, "Thank you, Your Honor." But the disappointment etched across his face speaks volumes. As he exits the courtroom, the weight of his financial responsibilities remains, unshaken and unrelenting. The judge's parting words linger in the air, a stark reminder of the law's rigidity. Legal agreements are binding, and without significant, provable changes, they hold firm. It's a sobering moment that underscores the complexity of child support laws and the lasting impact of decisions made during mediation. For Mr. Thornton, the battle ends here, but the challenges ahead remain as heavy as ever.
Entertain child support at that point, but nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
You're welcome. I just wanted to go over what you all witnessed in the Thornton case. Dad was appearing in court for the first time. He and mom settled at mediation for no child support. Well, now he wants mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support from mom.
This case serves as a powerful reminder of why it's crucial to fully grasp child support agreements and the strict legal hoops you must jump through to change them. A legal expert breaks it down. In Texas, altering a child support order isn't as simple as asking for a do-over. It requires a material and substantial change in circumstances. Think major shifts like a drastic drop in income, a new living situation, or a child's evolving needs. But in Mr. Thornton's case, the court found none of these factors applied, leaving the original mediation agreement untouched. As the video concludes,